Hey everyone, Kyle Hislop here from slapsold.com, and I've been a real estate agent since 2005. But before I got my real estate license, I bought and sold properties with my own realtor. The funny thing is, when I got my license, I pulled up the old documents I signed with that agent, and honestly, I had no idea what I was signing. Did I agree to give away my kids on possession? Was I supposed to perform an interpretive dance, upon deposit? I trusted my agent. I literally could have signed anything. Hopefully in the end, I bought a house. So in this video, let's talk about the contract to purchase and sale and dive into each and every clause. We'll talk about what you're signing and why. I'm gonna be honest, it's super dry stuff. I might need to bust out a dance move, mid-video, but I hope you can stick with me till the end. To start off, it's important to remember that the contracts have been crafted by real estate lawyers to put deals together. They are never in the benefit of the buyer over the seller or vice versa. However, real estate agents add to these documents, so it's important to make sure you understand what they are adding and why. All right, let's dive in. The first 2 pages of the document is called the information about the contract to purchase and sale. Here, we break down in pretty specific details important parts of the contract and why they are there. The most important is number 6, customary costs. At this point, every agent will stop and point out some super valuable information. Costs that the buyer and seller incur during this transaction. For example, one that should never ever be overlooked is the property transfer tax. In BC, this is a huge tax that the buyers have to pay when purchasing a home, and you want your real estate agent to explain it in full detail. If you want more information about this tax specifically, I did a whole video on it and I'll link it in the comments below. The first official page of the contract, we have the information of the agent's brokerage at the top. Below that is the buyer's information on the left and the seller's information on the right. After that, we have the information about the property being sold, the address, the PID number, and the legal description. Clause 1 of the contract to purchase and sale is the actual purchase price being offered, because generally that is the most important, but not always. Here we have it written and numerically, so it is very clear what the offer price is. Clause number 2 is a deposit amount, which some will be surprised to know isn't always a specific percentage, and honestly doesn't even need to exist in order to have a legally binding contract. However, the deposit shows the seriousness of the buyer, and generally, the seller will favor a higher deposit, especially in a multiple offer situation. The deposit can be included upon acceptance of the offer, during subject removal, or even after final subjects have been removed. When the deposit is needed will be described within this clause. For example, in this situation, it'll be received when all the subjects have been removed by way of bank draft. The deposit will be held in trust at the buyer's agent's office until completion. Clause 3 is all the terms and conditions that need to be agreed upon between the buyer and seller. Typically, this includes a lot of conditions the buyer needs to fulfill in order to create a binding contract. For example, make sure they have financing, have an inspection, look over the title, all that kind of stuff. All these items will have a time frame to complete, and once completed and removed from the contract, it becomes a firm deal. This is also the place where an agent will add in conditions to the contract, which won't be removed. For example, the home will be left in a clean condition, the seller warrants that all the included items will work on possession day, things like that. Again, these conditions need to be agreed upon between the buyer and seller, and it can get quite lengthy. It's not uncommon to see multiple pages attached at this point of the document. Clause 4 is the day the deal will complete, basically when the money will transfer from the buyer to the seller. This clause can easily be glossed over without much thought. However, that is a giant mistake. Your professional agent will know the value of completing on a specific day. For example, I never want to complete on a Friday, because if something goes wrong and the money doesn't arrive on time, the buyer won't get the keys and will have to find somewhere to live for the entire weekend, waiting for the money to transfer on Monday. Always want to make sure you allow another business day just in case something goes wrong, paying special attention to holidays as well. Clause number 5 is possession day, which, if we paid attention to what I said about clause number 4, should be at least 2 days after completion. Again, nice to have that bonus day in the middle should something go wrong, and it's happened. It's happened to me before. It could happen to you. Clause 6 is the adjustment date, which is generally the same day as possession. It's when the buyer will assume to pay all taxes, fuel, utilities, and all that extra stuff for the home. Clause number 7 will highlight all the included items that will be left with the home. It has some pre-built items in like fixtures, blinds, curtain rods, etc., but the buyer and seller will need to write down any additional items. Often included items are appliances and hot tubs and gazebos, but can really include anything within the home. It's important to remember the difference between a fixture and a chattel at this point in the contract. A fixture is an item that is permanently fixed to the home or property, and removing it would cause damage. Whereas a chattel is an item that is not attached. Best practice, if you want something, ask a real estate agent to document it in this location on the contract, regardless of whether you think it's a fixture or a chattel. It takes a few seconds, and in the end, it will save a lot of problems and confusion. Clause number 8 states that the home and the included items need to be in substantially the same condition on possession day. Meaning, if the fridge was included and working when the offer was made, it needs to be working on possession day. Really, just leave the home in the condition you would personally want to receive it in. Clean, tidy, and everything in proper working order. Clause number 9 is stating that the included title will not have any conditions on it that don't run with the land. For example, there will be right-of-ways for utilities and all that kind of stuff, which are fine, but there shouldn't be a builder's lien on the property because you didn't pay the roofer, stuff like that. Clause number 10 explains how the money will transfer from the buyer to the seller, certified check, bank draft, wire transfer, whatever you've agreed upon between your bank and you. Clause 11 indicates that all the documents needed to complete the transfer of real estate need to be at the land title office by 4 p.m. on completion date. Clause 11A discusses the seller's particulars in residency, including information like resident or non-resident of Canada, the Vancouver vacancy bylaw. These are all, things that are outlined in this clause. 11B explains what happens if the property is GST exempt or not. So for new homes, the buyers may be responsible to pay the GST, but there may be exemptions or even rebates. Clause 12 reminds the buyer the importance of time. This goes back to my example of what happens if the property doesn't complete on time and extension has not been agreed upon. Basically, the seller can terminate the contract, the buyer forfeits all the money they paid, and could potentially be sued. So time is very, very important to remember. Clause 13 is explaining the process of how the buyer's financing works should they require a new mortgage for the purchase of the home. Clause number 14 states that if the seller has some financial charges on the title, they can wait until they receive the finances from the buyer before clearing. Clause 15 explains some of the costs of purchasing real estate. For example, the buyer cost of conveyancing and possibly arranging a mortgage, and the seller bearing the cost of clearing title. Thanks for sticking with me, guys. We are on clause number 16. It reminds the buyer to make sure to have insurance in place by 12:01 a.m. on completion, as it's at that time that they own the home. Clause 17 indicates that any reference to a party includes their heirs, executors, and administrators. Clause 18 states that there are no representations or warranties other than that which is incorporated into the contract and potentially the property disclosure statement. So if there's something important to you guys, make sure you have it in the contract. Clause 19 is a disclosure that personal information will need to be collected and may in some cases be stored on a database outside of Canada. Know that as realtors, we never sell your personal information to Facebook, Google, or any other entity. Okay, clause 20 explains that when the contract completes, the seller will pay the agent's commission from the proceeds of the sale in accordance with the listing contracts that was originally signed beforehand. Clause 20A details that the contract cannot be assigned to another party without the written approval of the seller. Before this clause came into effect, any buyer could assign the contract to a third party and potentially profit from that assignment. However, that is no longer the case without the seller's permission. We're getting closer, guys. Clause 21 explains agency disclosure and who works for whom. Even though it has the option for limited dual agency, meaning one agent representing both buyer and seller, in the Fraser Valley, that is not possible. However, there are locations in BC that are considered underserved. They don't have enough realtors. And because of those situations, it's still in the document. Clause 22 highlighting that acceptance of this contract is irrevocable unless, of course, there are subject conditions for the seller or buyer that need to be fulfilled. Traditionally, more often for the buyer than the seller. Clause 23 is the only clause in this entire contract that is in capital and bold letters. This should tell you that this is important and maybe worth a read. It's reminding all parties that this is a legal document and you should read through the entire document before signing. Clause 24 sets the time the offer is available for acceptance. Traditionally, a buyer's agent is working to have this contract signed right away, so they won't have to compete with another potential buyer, whereas the seller's agent, they're never in a rush to have it signed. This is an important clause because it gets changed a lot and has major implications. For example, say there is an offer made, the seller decides to counter the offer and sends back to the buyer's agent. While waiting for confirmation from the buyer, the seller receives another offer. They would then need to withdraw their current counter in writing before they receive notice of its acceptance. At this point, they would be in a multiple offer situation, to the dismay of the first potential buyer. This clause has caused more headaches and more complaints than any other in this contract. Clause 25, guys, we're at the end. This is where the sellers date the acceptance and declare their residency. And just a note, the buyers declare their residency in clause 24. So that's it. If you lasted this long, that's impressive because this is pretty dry stuff. Going through a contract to purchase and sale, clause by clause, it can be a tad bit boring. Trust me, I know. I do this every single day. I find it very, very important that I go through every single clause with my buyers and my sellers before they sign anything. If you have any questions about this topic, please leave them in the comment section before. And as always, if you need a realtor to represent you in the Fraser Valley, give me a call. See you next time.